So thanks a lot for being with us. First of all, excuse my French accent. And we are so happy to have you today to discuss data protection, which is such a critical issue in Europe. So as a lawyer, you've been fighting for data protection for 15 years. People don't know much about you, but you may be the only or one of the only men in Europe who scares the tech giants, such as Google, Amazon, or Meta. So, Max, what is your story? Why is data protection so important to you? And why does it matter for all of us?
Yeah, then sorry for my Austrian accent in return. And I actually work on privacy for a longer while. I was in exchange in the US and started to see how things are a bit different there than in Europe, and also started to worry about some of these things. We started actually going against Facebook originally because at the time they were the big kid on the block. Now it's obviously for old people by now. And it's mainly about really the compliance with European law as we have it. We're a bit unique globally because we have this fundamental right to privacy. Many countries in the world have privacy laws that are similar to the European Union, but really having it as a fundamental right is very specific. However, once you work in that, what you realize is that it's hardly enforced ever. So that is actually the biggest issue I see with a lot of the regulations we start to have in Europe that are actually making sense somewhat, is that we're then actually not following through with them, and a lot of the companies don't comply with that. And that is mainly what we work on. And that produced fines of up to 1.2 billion for Facebook in one of our cases. One big fine by the French Data Protection Authority, the CNIL, was 50 million euros that was triggered by one of our cases as well. So that's basically what we're up to. And especially we also then look at data transfers to the US, because after this non-disclosures, we had to realize how much of the data is not just used by the industry, but also by secret services via the industry. So basically, if you can get into Apple and Google, you basically have the data of each phone in the world by now. And that is where some of the work was done on as well, which is especially on these deals we have with the US on data transfers.
Can you talk a little about None of Your Business, your non-profit organization?
Yeah, so we're based in Vienna, but we're a European organization, a nonprofit organization. So we have lawyers from more than 10 countries work here with us, actually trying to enforce the law that we already have. So ever since 2016 and then coming into force in 18, we had the European Data Protection Regulation, so the RGPD in the French acronym, the GDPR. And that is actually the core pillar that we're working with. And we usually try to get these cases in front of the regulators. So for example, the CNIL in France, but also the regulators throughout the European Union, but also take action against the regulators if they actually don't enforce the law. And there is new stuff coming up. For example, ever since last summer in Europe, we have collective redress, so kind of a class action, which is also interesting because so far there was very little consequence if you didn't follow the rules. But if you, for example, have 1 million people or 10 million people that all ask for 100 euros in damages, then maybe some of these big companies also reconsider how much they can ignore the law or not.
So in 2015, you attacked Facebook because you thought that Facebook was illegally transferring data from the Europeans to the US. The European Court of Justice agreed with you and in a shocking move at the time, cancelled the Safe Harbor Act, which was the legal frame between you and the US. And 5 years later, in 2020, the same thing happened again with the new agreement, which was the Privacy Shield, for the same reasons, and again, because of you. And now we have the third act, we have a third text, which is the Data Privacy Framework, and you are fighting it again. So what happened? Why third action? What's wrong this time?
Yeah, so as a fundamental issue that we have ever since 1995 in the European Union, we actually have an export control on personal data. So if it's personal data, the standard rule is it cannot leave the European Union because there is a protective law here. And if the data would just go outside, it wouldn't be protected. Now, there's different ways to still transfer data abroad if it's really necessary. But for example, also for outsourcing, where it's really about just being cheaper or easier to have it in the American cloud, there are tools for that. And one of them is called adequacy decision. So basically that the European Union declares another country to be more or less the same when it comes to privacy as Europe. That's usually countries like Switzerland that have a very similar law. Now, the US has pressured the European Union to also be accepted as having just as good privacy as in the European Union, which I think for most average people is already hard to comprehend that that could be true. Nevertheless, it was passed in 2000, so at a time when I was 13 years old, and already then people said, that's a bit weird. It got very problematic after the Snowden disclosures, because we now know that there is a surveillance system called PRISM, where the NSA and the FBI can basically take the data out of the big tech providers' databases secretly without any kind of court approval or anything for the individual case. And you're under the American law basically not protected if you're not if you're not an American citizen. So that means that a lot of the data that we have in the big cloud systems are really vulnerable and not properly protected. And that was already a problem under the first instrument. The Court of Justice told the European Commission, you can't do that. We won the case. 3 months later, the European Commission issued more or less the same decision a second time around with a new name on it. So it was called Safe Harbor, then it wasn't called Privacy Shield. This next one was then also turned down by the European Court of Justice for more or less the same reasons. And the reaction was that there was 1.5 years of discussions, and then more or less the same deal came around a third time. So we're a bit in a situation where the executive part of the European Union, so the European Commission, is just basically issuing these decisions over and over again, and we then have to go after them. It becomes a bit of a rule of law issue, because if the Supreme Court of the European Union says no, and then the executive is just doing it over and over and over again, I think we have a bit of a broader, let's say, rule of law issue that we're fighting here that goes beyond privacy alone.
What do you think your fight reveals about Europe, about data sovereignty?
I think what the biggest issue is we have in Europe, we talk about these things. We even pass legislation, which in other big blocs, I mean, if you look globally, if you look at democratic blocs, basically the US is almost unable to pass legislation anymore, even if very consensual legislation hardly gets passed. Then there's no other big bloc really that has the power of the economic power that the European Union has. So we're in a very specific spot that we actually have a very big economic bloc that is able to regulate stuff like that, which is really, really cool. And a lot of the world looks at that. The problem that I see is that we're not following up with it. So we're basically passing new and new and new legislation. And just this session of the European Union, we have elections this summer, but the last 4 years showed a lot of new laws being passed. But the big question is it enforced in reality? Because to actually impact people's lives and to actually protect people in reality, there has to be a consequence. And especially the Silicon Valley has a history of really just pushing the boundaries. And Facebook had it at some point as a slogan, move fast and break things. And one of the things that they break is the law. And there is very little consequence so far. So I think the criticism there may, to a certain extent, also be on the member states, because the European Union usually issues the laws and the regulations and so on. But then it's up to the member states, each individual member state, to enforce that and to put the executive to use. And there we see huge gaps, especially in countries like Luxembourg or in Ireland, where most of these big tech companies are residing. There, the regulator is oftentimes inclined to look the other way instead of really pushing stuff forward. And that is a bit of a functioning problem, I think, that we have in the European Union. So we pass laws, but then if it's not complied with, there's very little consequence from that.
It's a lack of political will, or it's a renouncement?
In some of them, it's a lack of political will. It's especially with the data protection authorities a bit specific, because they're officially independent authorities. So the justice minister cannot give orders to that authority. So in that sense, any justice minister can just say, I'm very sorry, I appointed someone that I knew that is not going to do anything for 8 years, and now I'm very sorry because I can't do anything about it. And that is a bit what we see in some jurisdictions happening. And also, I mean, usually you could go to courts, but for example, in France, the CNIL takes the view that you don't have a right that they actually take action on anything, which is very unique in Europe. But even in the countries where you do have a right that they take action, going to court oftentimes in Ireland, for example, costs more than 100,000 euros. So we are running on donations, but even for us, that's hard to swallow as a number. So we see that then if the regulator really doesn't want to do its job, they have a lot of leeway not to do their job. And that in the end is political.
And in France, we have a French initiative against the Health Data Hub, which is a big data set in health. And this initiative could end up breaking the data privacy framework. What do you think of it? Do you think it will work?
So I think once this case gets to the Court of Justice, and that's the big challenge, you need to have a national court to actually refer to the Court of Justice, and that is tricky. And especially my understanding is that in France, but I'm not an expert in French law, that would go to the Conseil d'État. And the big question is, would there be a reference? To a certain extent, once you're at the Court of Justice and the case is properly pleaded, I think there's a 99.9% chance that the new deal is going to be killed as well. First of all, because it's basically the old deal with another headline, but also emotionally because these judges have already told the Commission twice you can't do it. If they come around the third time with more or less the same thing, there are slight differences, it will be a matter of the authority of the Court of Justice to say, you can't just repeat the same act and hope that the third time we don't see it. So I think there is a very high chance that anything like that will be scrutinized even more maybe than the first 1 or 2 deals that we had there already.
And so I have a last question, because in less than 1 hour we will have Thierry Breton on stage. And what do you have a message for him? What do you want to say to him?
To be honest, I don't have a very specific message. We're basically litigating in reality. We're not political in that sense. We're not a lobby organization. But I think fundamentally the bigger picture that we have, and that's really interesting, is that we have to step up from legislating, which is already much more than most other blocs in the world does, to actually enforcing it. And I think that is where the resources have to go to, and the political will and political backing has to be there as well. And last but not least, the CNIL usually is one of the higher, the more serious enforcement ones. So we usually look at France for that in a positive way as well, I have to add.
Thank you very much. It was a real pleasure to have you today with us, even in remote. Thanks for your time.
Thanks a lot.
Thanks. Have a nice day.